back to Legal Spirits, the podcast of the Mattone Center for Law and Religion at St. John's University. I'm Mark Movsesian. One thing I've learned over the years is that for many law students, and also many practicing lawyers in the United States, international courts can seem both important but also somewhat opaque. We know the names of the courts and some of their landmark cases, but not always how these institutions work in practice. That's true of the European Court of Human Rights. We know some of its landmark decisions, but we don't always have a clear sense of the structure and function of the court. Today's episode is meant to shed some light on those issues. I'm very pleased to welcome Judge Ioannis Ktistakis of the European Court of Human Rights, where he served as the judge elected in respect of Greece since 2021. Before joining the court, Judge Ktistakis was a professor of public international law and human rights at Democritus University of Thrace, a practicing attorney before Greek and international courts, and lecturer at the Greek National School for the Judiciary. This episode grows out of his visit to St. John's Law School last fall, where he met students and spoke about the court's work. And the students had many questions, and those conversations inspired us to continue the conversation here on Legal Spirits. On this episode of Legal Spirits, a conversation with Judge Ioannis Ktistakis. Please stay tuned. Welcome to Legal Spirits, Judge. It's a pleasure to have you with us.
Thank you very much, Mark. If I'm allowed, Mark, it's a real pleasure to be with you, and I'm grateful for the invitation. I'm very much enjoying my visit to St. John's and the conversation with the students, so I'm delighted to continue that discussion here with you.
Thank you, Judge. We're very glad to have you with us. So, to start, I'd like to talk about your own professional path. You've done many things. You've done academic work, you've practiced as a lawyer, now you're a judge on an international tribunal. Tell me a little bit more about your path. How did that work, and how did you come to be put on the European Court of Human Rights?
Yes, my professional path has been somewhat hybrid, and I think that that combination explains my interest to the European Court of Human Rights. I began as an academic, teaching public international law and human rights law, but at the same time I was always involved in legal practice, both before domestic courts, Greek courts, and before international bodies, including Strasbourg, or mainly Strasbourg. That dual experience shaped the way I approach human rights law, not as an abstract system of principles, but as something that must function in real legal systems under real institutional and social constraints. Over time, the European Court of Human Rights became a natural point of reference because it sits precisely at that intersection between theory and practice in international law. My election to the court was the result of a national selection process in Greece, followed by the national, if I can say, the national election by the Parliamentary Assembly of the Council of Europe. It is a demanding and highly transparent process, and it reflects the idea that judges at the court are not representatives of their states, but independent international judges elected through a collective European procedure. Usually in Europe, there is no election of judges. The judges are judges by career in the vast majority of the European states, in domestic legal system, judicial system. And this is the system of election before the European Court of Human Rights is an exception.
Yeah, so Judge, that was one of the things that most surprised our law students, the process of selection for being a judge on the court. And you've said it's somewhat different from the United States. And you also said that you're not selected in respect of your home country. You're not there to represent Greece. So what are the processes once you are appointed to insulate you from outside pressure, from political pressure if I may say, from your own state or from other states?
May I describe the process in detail and then
Yes. Okay, of course.
answer directly to your question?
Okay, sure.
Um, um, well, each member state of the Council of Europe, and now there are 46 member states, propose a list of three candidates following a national selection procedure that must meet criteria of transparency, merit, and gender balance. Those lists are then examined by an advisory panel of experts, retired senior judges at the Council of Europe. And finally, the judges of the European Court are elected, as I said, by the Parliamentary Assembly, which is composed by parliamentarians from all the 46 member states. Following, of course, an interview, I, I was interviewed by the committee of the Parliamentary Assembly, and the committee asked me technical and other questions. And finally, the committee prepared a report for the three Greek candidates at the time, and they proposed me to the plenary, which is not, of course, automatically. They propose, they recommend, and finally there was the vote by the 324 members of the Parliamentary Assembly, members of the Parliamentary Assembly of the Council of Europe. Now I go to the independence aspect of the independence of the judges in the European Court of Human Rights is based in three very important pillars. The first is the no renewal of our mandate. Then no one of us can ask the re-election in his position, her position. And this, I think, is very important, that there is no thoughts that you must be a good judge in order to have, again, the support or to be the choice of the Parliamentary Assembly. Then
I see. So you cannot be reappointed.
You cannot be reappointed, re-elected. Then this is also out. Once you are elected, you stay for 9 years, unless if you want to resign, but this is up to you. The second point is that we enjoy all the high privilege and high immunities of the international organization. Then we have this what the public international law is described as immunities and privilege of international judges, which are in the same level like the ones that the judges of International Court of Justice are enjoying. Then we have all this framework of protection. And the third pillar of our independence is, of course, a good salary, including the prohibition, the direct prohibition of working or doing other jobs during or have other conflicts during our mandate. I think these are the three pillars of our independence.
I see. Okay, thank you, Judge. So let's talk about the internal workings of the court. You've described how judges are elected, but from the outside, especially from the United States, the court's process can seem very opaque. So if you were explaining to a US law student the process of a case at your court from application to judgment or even after judgment, what is the process? What is that like?
Yes. At its core, the process begins with an individual application lodged by person, a group of individuals, or sometimes an organization, an NGO or other organization, claiming that a state has violated their rights under the European Convention of Human Rights. Then the individual application lodged before the court There is no limit concerning the nationality of the individual or the group of individuals. The only limit is the jurisdiction of the court, which is described in Article 1 of the Convention. And this means that everyone who is under the jurisdiction of the one of the or more than one of the 46 member states of the Council of Europe, then the court has also the jurisdiction to adjudicate each individual application. Most applications are filtered out at an early stage because they don't meet the admissibility criteria. One of the criteria is the one that I described. We cannot, no one can bring a, an individual application against the United States before the European Court of Human Rights, even if it himself is a European. Okay, but if the case, those who are proceed, and this is about, I can say, the 20% of the initial application lodged before the court. These are communicated to the respondent state. Written observations are exchanged between the applicant and the defendant state. And in some cases, a friendly settlement is explored. If the case goes to judgment, it is examined by a chamber, or in more exceptional cases, by the Grand Chamber. The judgment addresses both admissibility and merits, and if violation is found, it may include just satisfaction. What is important to stress is that the European Court is not a for instance court. It does not relitigate the facts, but reviews whether convention have been respected in the particular case application before the court.
Right. So it's fair to say it's an appellate court, really, as Americans would understand this. It's not a court of first instance. You are taking the facts as they have been determined, and then you're giving a legal opinion. Now, you talked. One thing that shocked the students, shocked me too, at St. John's, is the volume of cases that your court has, Judge. I think you said tens of thousands of cases a year, if I'm not mistaken. And so, how do you manage that as a court? How can you manage that volume of cases while maintaining consistency and coherence across your jurisprudence?
Yes. We examined last year, 2025, we examined 37,000 applications.
37,000, right. I hope listeners heard that. 37,000.
I think that the court, and I'm very proud as a member of this court, the court relies on a sophisticated filtering system, well-developed case law techniques, and the work of an excellent registry. At the same time, coherence is ensured through established jurisprudential principles. We use pilot judgment in structural cases, and when necessary, refer to the Grand Chamber. There is always, I must confess, that there is always a tension between efficiency and depth, but the court is acutely aware that consistency and legal certainty are essential for its legitimacy. I think that if I can conclude, the court is the register of the court is a very efficient manager in the field of judicial work.
I would think it has to be extremely efficient with that volume of cases.
Yes.
All right, so Judge, we've talked about the selection process, we've talked about your path, we've talked about the process of a case through the court, but the Mattone Center, our center here at St. John's, is especially interested in church and state and religious freedom. So let's turn to religious freedom a bit. Your court, like the US Supreme Court, like the British Supreme Court, like I guess high courts around the world, when it considers religious freedom cases, it often has to balance things. It has to balance the applicant's religious freedom with other concerns like public order or state neutrality or other kinds of desirable goals. So how do you think your court does this, and do you think your court is doing a good job at balancing these different public goals?
Yes, well, religious freedom cases are often difficult precisely because they involve competing rights and values, as you said before. The court approaches these cases by recognizing that freedom of religion is a foundational right in a democratic society, but at the same time, not an absolute one. The key is of course proportionality. The court asks whether interference pursues a legitimate aim, whether it is prescribed by law, and whether it is necessary in a democratic society. That analysis requires sensitivity to context, especially when issues of pluralism, equality, or public order are involved. Um, I want to mention that the court has been established by the convention in 1950. And
1950, you said 1950.
1950. And the year of the signature of the convention. And the first ever judgment of the court for in the context in the field of freedom of religion was in 1993. It was the Kokkinakis case.
That is the first case we teach in our comparative law and religion seminar. It's Kokkinakis.
Yes. Why in 1993, when there were a lot of other application related to freedom of religion before 1993? I think because of 1989. I mean, the radical change in the political situation in Eastern Europe and the emerging question of religious and other minorities in all these countries. Then I think that the court is, of course, a court, but as every constitutional court, we say, here in Strasbourg, we say that we are the constitutional court of Europe, and every constitutional court has to take into consideration the major political development and evolution.
That's really fascinating. Judge, I've never heard it described that way, as the Constitutional Court of Europe. I think you've given us a title for this episode, actually, because that really is, I've not heard that. And look, we have the same issues in the United States that, in fact, when I hear you talk about proportionality, to me, it sounds rather similar to what we call strict scrutiny in the United States, that the court has to try to ask, is there a compelling governmental interest for what the state does, and has it chosen the narrow means? I think it's very similar. Another technique that, as I understand it, you use in the European court is the margin of appreciation doctrine. And this is something which is unlike anything in the United States. And when I teach this in my comparative law and religion seminar, the American students become very, very skeptical about this. They think the margin of appreciation kind of makes the European convention sort of useless once you have this. So I'd like you to describe it, actually, the margin of appreciation doctrine, and whether you think it's a valuable tool for your court.
Yes. Well, the margin of appreciation reflects the idea that national authorities are sometimes better placed than an international court, like the European Court of Human Rights, which is an international court by foundation, to access local needs and contexts, particularly in culturally sensitive areas like religion. In practice, the breadth of the margin depends on several factors: the nature of the right at stake, the existence or absence of of a European consensus and the quality of the domestic decision-making process. Importantly, I can say that the margin is not an abdication. The court always retains the final word or whether convention standards on whether convention standards have been respected. There is no a single answer how it works, the margin of appreciation, but I want to emphasize that there are four levels of margin of appreciation, four parameters of. The first is the nature of the right at stake. Is different to have a margin of appreciation in Article 8, in Article 9, or in Article 10. That means freedom of family, freedom of private life, freedom on religious freedom, and freedom of expression. The second is the existence or absence of a European consensus. The court usually finds that when there is a European consensus, then the margin of appreciation is not extended. In the contrary, is limited. When there is no European consensus, then there is no recommendation, not national legislation on this issue, then absence of European consensus, then the margin of appreciation of the defendant state is larger. And of course, one of the discussion is the quality of the domestic decision making process, which is also one of the parameters of the margin of appreciation examined by the court.
Yeah, thank you. Well, also, I mean, another defense you might think of is in a regime that covers countries going all the way from Armenia to Portugal and Norway to Spain and Greece. You kind of have to have a margin of appreciation because
Yes.
these really are different cultures, and that's what I try to explain to my students, that this is kind of a necessary thing for the legitimacy of the court. Judge, looking ahead, I want to focus on religion especially. Are there particular issues involving religious freedom? I don't know, like religious accommodations or public religious displays. Do you see any particular crises involving religion that are going to come up before your court in the near future?
Yes, I think we will see increasingly complex cases and the intersection of religion, social pluralism, and individual autonomy. Questions of religious expression in public spaces and the role of religion in increasingly diverse societies, I think will continue to challenge the court. I think that this conflict between freedom of expression, criticism, and the other way, the right, if there is a such right, of the believers to have to feel a respect, to have a respect for their religion, is always, I think, a field of conflict, and there will be more and more cases that either believers will apply to European courts and ask protection of their religious beliefs, but people who don't respect their beliefs, by criticizing their beliefs, by making music and songs against their beliefs and their sacred books. And from the other side, there will be more and more individuals like artists, journalists, public opinion figures, influencers in social media who will be punished by the national authorities for violation of of the religious beliefs of the majority of the population in a certain country, and then they will come to the court and claim their freedom of religion, freedom of expression, in comparison with the respect of religious beliefs of the others. I think that these two rights, I can say, freedom of expression against freedom of religion, will be and more present to our case law.
Yeah, that's very interesting. Well, freedom of expression and freedom of religion often overlap in U.S. cases too, and
Mm. Yes,
it's not a surprise to me to hear that it's also going to be the case, you think, at the European Court.
yes.
So, Judge, I do want to get to this, and many of our listeners are law students, and some of them are thinking about careers in international law, including international human rights law. And I wonder if you'd like to say anything to them, if you have any advice to students just now starting out on this path. Maybe they want to be human rights lawyers, maybe they want to be human rights judges one day. What sort of advice would you give them?
Yes, my main advice will be to combine intellectual depth with practical experience. International human rights law are demanding fields, and it is important to understand not only um, the dogma and the ideas, but also the institutional procedures and constraints. This is my main advice. But I would also encourage students to be passionate, of course, and open-minded. Careers in this field are rarely linear. Language skills, comparative perspective, and genuine curiosity about different legal culture are very valuable. Finally, I think never underestimate the importance of integrity and independence of thought, qualities that matter as much as technical excellence in the field of international human rights law. And last sentence,
Of course.
I encourage them to read every morning the news, the world news, and the news of their country, but also the world news. The student, the professional, the jurist, the judge who knows the news is always better prepared to examine individual cases
Well,
about
that's
human rights.
that's very interesting, Judge, and I think it's useful to hear that because so many law students, good lawyers too, become so focused on their work and the doctrine that they are not paying attention to these other things because they think, well, that's not my job, that's not my business.
Mhm.
You don't think that. You actually think
No,
the
no, no,
opposite.
no, no, no. I don't think. I think that they have to work in both the two fields, but not only to be, let's say, not to be out of the everyday news, everyday demands, everyday. It's not necessary to read and to accept them. In the contrary, but you must know what are the social constraints in this field.
Great. Well, Judge, I think we'll leave it there. Let me say, Judge, thank you very much for joining us and for your insights into the work of the European Court. And as we say in the United States, you know the way, so please come back.
Oh, thank you so much, dear Mark, and thank again the students that they follow our conference and my talk in the St. John University. Thank you.
Thank you, Judge. And thanks to our listeners for tuning into Legal Spirits, which is the podcast of the Mattone Center for Law and Religion at St. John's. To learn more about our work on law and religion, and especially comparative law and religion, please visit our website, which is the Law and Religion Forum, or follow our YouTube site, or subscribe to this podcast. And you can find the podcast wherever you stream your other podcasts. But that's it for now. See you next time.